My name is Christian Maynard, and welcome to a breakdown of cannabis laws in Arkansas. Information is largely drawn from the National Organization for the Reform of Marijuana Laws. Arkansas occupies a unique place in cannabis history. It's the home state of President Bill Clinton, whose famous claim that he tried cannabis but didn't inhale became one of the most enduring cannabis stories of the 1990s.
When I was in England, I experimented with marijuana a time or two, and I didn't like it, and didn't inhale, and never tried it again.
Today, Arkansas policymakers are less concerned with whether someone inhaled, and more concerned with who is legally allowed to do so. As of 2026, Arkansas operates under a medical-only cannabis system. Adult-use cannabis remains illegal, but qualified patients may legally obtain cannabis through state-regulated dispensaries. Voters approved medical cannabis in 2016, and the state has since developed a network of licensed dispensaries and cultivation facilities. So while Arkansas is not among the states embracing full legalization, it has moved well beyond the days of "I didn't inhale." Arkansas maintains a relatively broad list of qualifying medical conditions. Patients may be eligible for conditions such as cancer, PTSD, multiple scoliosis, Crohn's disease, HIV and AIDS, severe arthritis, and a variety of other chronic and debilitating illnesses. The Department of Health may also approve additional qualifying conditions over time, allowing the program to evolve as medical evidence changes. Arkansas permits a variety of cannabis products, including flower, concentrates, and edibles. Qualified patients may purchase up to 2.5 ounces of medical cannabis during a 14-day period. Edibles may not contain more than 10 milligrams of THC per serving, and products cannot be designed to resemble candies or other products primarily marketed towards children. And adults are prohibited from smoking cannabis in the presence of a pregnant woman or a child under the age of 14. Home cultivation is not permitted in Arkansas. Instead, patients must obtain cannabis through state-regulated dispensaries. Arkansas currently allows 40 dispensaries and up to 8 cultivation facilities. Caregivers are permitted and may assist qualified patients who are unable to obtain or administer cannabis on their own. Unlike some states, Arkansas does not recognize out-of-state medical cannabis cards. One area that Arkansas stands out is patient protections. The state provides legal protections in several areas, including employment, housing, school enrollment, organ transplant decisions, and child custody proceedings. Employers generally may not discriminate against someone solely because they are a registered medical cannabis patient. Parents cannot automatically lose custody or visitation rights simply because they participate in the medical cannabis program. These protections are more extensive than those found in many medical cannabis states and reflect an effort to integrate medical cannabis patients into existing legal and social institutions. When it comes to driving, Arkansas uses an impairment-based approach. A person may be charged with driving under the influence if cannabis impairs their reactions, motor skills, or judgment to a substantial degree. Importantly, being a registered medical cannabis patient is not a defense against a DUI charge. Arkansas also operates under implied consent laws. By driving on Arkansas roads, motorists are considered to have consented to chemical testing if lawfully arrested for impaired driving. Refusing a test can result in a license suspension and other penalties. The state also permits sobriety checkpoints, which have repeatedly been upheld by the courts. Public consumption remains illegal, and Arkansas does not authorize cannabis consumption lounges. Outside the medical cannabis system, possession remains criminalized. Possession of less than 4 ounces is generally considered a misdemeanor for a first offense and may carry penalties of up to 1 year in jail and fines of up to $2,500. Subsequent offenses can result in felony charges and substantially greater penalties. So while Arkansas has embraced medical cannabis, it maintains hesitancy towards an adult use market. In summary, Arkansas has developed a relatively robust medical cannabis program with broad qualifying conditions and unusually strong patient protections. At the same time, adult use cannabis remains prohibited, home cultivation is not allowed, and criminal penalties continue to apply outside the medical system. While Bill Clinton didn't in hell, you probably shouldn't either unless you're a medical patient. Thank you so much for watching. To support my work, please like the video, get subscribed, and comment what I should cover next.